Sjoera, and I will work at the European Commission at the Director General CNECT, and I'm a seconded national expert from the Swedish Post and Telecom Authority, where I work with data breach notifications. I will just briefly introduce this topic, and then I will hand over to the panel. And also, I would just like to remind you that we will have a session for Q&As in the end, so save your questions for the end. We have seen several large data breach incidents during the years, and it's a common topic in the media today. And of course, with every new incident, the discussion comes up on how to handle it. One of the topics that often is discussed is, of course, data breach notifications. And in Europe, over the last decade, we have seen waves of legal obligations or legal rights coming up where these regulations have been shown. They have come from sector-specific legislations, like in the e-privacy directive or the framework directive, to a wider aspect of recipients, like in the NIS directive and, of course, the GDPR. In other parts, like in the US, we have seen these laws also being around for an even longer time. And they have taken different shapes and forms, and this is what we will discuss today, on how this can be developed. Are they providing any positive effects, or is it only for the worse? But if there are any positive parts, what is it and how can it be improved? We will see both theoretical and practical aspects of this here at this session. And I hand over now to the moderator, Professor Zarsky from Haifa. Please go ahead.
Thank you very much, Anders, who was too modest to introduce himself. So Anders Lindell joins us from DG CNECT. He's on secondment from the Post and Communications Authority in Sweden, and also dealt with these issues in both his capacities. This is a panel organized by University of Haifa's Center for Law and Technology, and also its Center for Cyber Law and Policy. And this is an issue I've been interested in for some time, and I hope to write about it academically also. We've heard during the 2 days here at CPDP several times that breach notifications were addressed as a helpful tool to both empower individuals and also to perhaps lead firms, incentivize them to act in a more secure way. And I think that if too many people agree on something, so that's a problem. So in this panel, we'll try and think about breach notifications, what they're good for, and maybe what they're not so good for. We'll start out with Lukasz Olejnik, who is an independent researcher and consultant, to start to get us understanding how breach notification works, both on a technical and legal level. So please, Lukasz.
Hi. So thanks for the invitation, first of all. Now, I will try to introduce the breach notification, the concept and mechanism, and also basically argue why this is a great thing. Now, breach notifications are now an important aspect in any incident response where user data are concerned, so mostly any. But first, let's start with the motivations. So let's face it, companies around the world have a pretty much weak posture when it comes to cybersecurity and privacy. This, to some degree, also relates to the big ones, too. Highly valued. Now, so far, we did not know much about this level, and also it was unclear the reason why do we have the lack of transparency, because it's clear that incidents happen, and especially in some sectors, they are usually not being disclosed. Now, companies are made to make money. That's a simple economic fact. So private companies exist to make money. Now, it's often cheaper to move fast and recklessly, and possibly manage any fallout like breaches, this kind of fallout, manage this later. So it's a sane and deliberate strategy. Now, breach notifications are here to impact on this kind of behavior. It's an interesting mechanism. It requires companies to report breaches to data protection authorities and sometimes also to users. So it can motivate companies. It's among the prime factors, actually, that requires to motivate companies to be able to detect breaches, to detect, escalate, triage, manage, and solve them, investigate them, also in a timely manner. So this obviously improves the cybersecurity and privacy posture, both directly and indirectly. It's estimated that the average dwell time, the time that I'm speaking about cyber attacks, cyber espionage sometimes. So the time when the attacker is present in the attacked networks, so that the time frame of a breach. So it's estimated that the average time is 1 to 2 months. Sometimes it exceeds even a year. So it's sometimes very challenging. So detection is very important. And breach notification improves user trust towards companies because companies establish a communication channel with the user by being honest and open about what happened, what is the risk, what is the severity, and what to do. So it of course requires to explain how the users might want to move forward. Now, for some users, it's obviously about trust and security, but also about being aware of what happens with their data. So for example, well, because often users do not really have a choice whether to use a service or not. There is a power imbalance. Now, obviously, in the communication to the user, companies need to be upfront. They need to be crisp and clear. The users need to be able to understand what are the implications, and even if they do not understand, they will still be able to reason that, well, oh wow, my password may have been breached. Then reason, I have reused this password in many other places. Consequently, maybe the user would conclude that it's a good idea to change those passwords. That's just a mock example. Also, it's another important transparency factor is that if the users would see that a certain company is affected with data breaches regularly, on a regular basis, it's a clear communication, it's a message to the user. Now, for data protection authorities, it's also an important factor. It provides the general picture about the breaches in a country. It also provides the picture of the long-term cybersecurity and privacy at a particular company. Also, many DPAs, data protection authorities, never had access to this data. So to sites, I did speak to many, and around the time when GDPR was entering into force, the sites, it was like this particular DPA, they never had this data. So they have no idea what is the rate of breaches. So this obviously provides huge value to states, to governments. Holistic view, it allows to reason strategically about cybersecurity and data protection, so they see the actual extent. That's because this obligation, when followed, would provide a reliable metric. But why does it work? Because it works because it is obligatory, and if it's obligatory, naturally there needs to be some kind of time frame when to report it. So 72 hours have been picked. It's more or less a trade-off. Sometimes it's very strict, but the main motivation is to inform the data protection authority as early as possible. But the timing is both strict and somewhat indicative. It's strict because it's best not to go beyond, and it's indicative because, well, let's face it, 72 hours is pretty sharp. It's quite difficult to get things done, the full investigation done in 72 hours. It's very ambitious. So that's why it's not required to jump as crazy, because there's an option to inform the data protection authority in phases. So once more information is available, it's simply being updated. That's natural and that's good, because investigations, well, they do take time. How many of you has heard of Singaporean health breach from the last year, when the Prime Minister's data was also affected? So it was 1.5 million user data, including Prime Minister. So the full report investigation, it's 400 pages, is very thorough, but the full report has been released recently, so it takes time. We also saw breaches of Cloudflare, of Facebook, of Google, even last year. It's quite simple to notice that information is being provided in stages. That's because investigations take time. The important question is that what if one faces a very strong threat, like cyber espionage, state-sponsored actors? It's typical that threat hunters want to observe this. So reporting such a breach might undermine this kind of investigation. There are, of course, exceptions to the 72-hour rules, but this is one particularly important thing to consider. Now, let's jump into another topic. Because we discussed what are the advantages for users, DPAs, and states, and what is the maybe somewhat motivation behind the timing. Let's speak about mechanics of disclosure. Let's say what happens when a company discovers an incident. Obviously, people need to be allocated, resources need to be allocated, possibly also external investigators need to be engaged. It takes time. So this is time, resources, like money. It, of course, needs to be a high-level decision. So even if external contractors are being engaged, it's good to have someone that has a good understanding of incident response, good understanding of technology, and good understanding of communication. This person should be interested in drafting the communication to DPAs and to the users. And of course, these messages differ. You write information to DPA in a very different way than that directed to the user, which should be crisp, clear, short, concise, and understandable. To do that, there is really a need for knowledge. Again, I will recall the Singaporean health system breach. That breach has been communicated. Of course, 1 million Singaporean dollars have been awarded, but the breach have been communicated using many channels. So, website, text message, mail, phones. That was important, that was exceptional, but picking channel is really important. And also, what is important is structuring the message in a particular way as to adapt towards the channel that will actually be used. So I've spoken of resources, and yes, of course, the mirror employment allocating workforce to that, this takes money. It takes money. It's difficult to estimate the full cost of a bridge, but it's clear that bridge notification requirements will be an integral factor in this cost. There are some estimations already behind this cost. Obviously, costs are the function of quality, the type of data, and also the number of data, the nature of the company, the nature of the bridge. There's also hidden cost, reputational costs, and the competent people are assigned to the task are assigned precisely because of this, to reduce the risk to reputational cost. And this is also why bridge notification exists now. So how much do companies, how much companies might pay for the bridges? There are some estimations based on surveys, some more or less measurements. So it's a function. It might vary between maybe $0.50 to $5. That really depends. It's per record. So assuming that we have a 20 million record bridge, let's say that the total cost of the bridge might be $200 million. That will be more or less, let's the ballpark figure, 3 million for merely allocated for the bridge notification process. So, but in summary, I would like to argue that bridge notifications provide pretty good value to companies because they improve trust. So it's a value to companies. It's also a value to data protection authorities, obviously. It's also useful to users.
Thank you very much, Lukasz. So just to sum up what we see here, under GDPR, we see two sets of notification requirements: a notification to the authority, and in more graver instances, notification to users.
In GDPR.
Under GDPR, yes. And also, analytically, we see two sets of motivations. One I refer to as ex post motivations because they help the user after the fact to take action. For instance, if he was silly enough to use his password in a few places, now he knows to change that. And there's what I refer to as ex ante motivations, which are the firm knows that if it will be subject to a notification requirement, this will lead to dire consequences to said firm, and therefore in advance will take steps to limit the chance that such notifications will transpire. That's just very broadly drawing out the philosophy here. So let's try and think about that a bit more. And now we move to hear from Anouk Wischel from Privacy Company. She's a legal consultant on privacy issues and dealt also with breach notification. Please, Anouk.
Thank you very much for the introduction. Like Tal mentioned, I'm from a Dutch company called Privacy Company. And as some of you might know, in the Netherlands, we already have a notification duty since the 1st of January in 2016 under the former Dutch Data Protection Act. So we have quite a lot experience, gained a lot of experience over the past 2 years about how to deal with notifications and the obligation. The former chairman of the Dutch DPA thought that this new legislation would lead to a higher priority of security in development of new products and services. He said the obligation to report data breaches is not an end in itself, but a means to ensure that data breaches are prevented. And by the end of 2016, 5,500 data breach notifications were made to the Dutch DPA. the DPA said that this was a sign of increased awareness about the importance of security within organizations. And one of the questions that was asked in advance was, will the reporting fatigue substantially impact the effectiveness of the obligation? Yes, in some cases it might lead to some fatigue, but in my opinion it does not lead to substantial impact of the effectiveness of this notification. For example, in 2017, the Dutch Data Protection Authority chooses to create an exception for some organizations to perform a bulk notification. So there were some companies who were sending a lot of information through a letter to the data subject, and a lot of things went wrong with it. So the DPA said, well, to minimize the amount of notifications that you need to make, it's okay if you just, by bulk notification, inform us about this, for example, at the end of the month. So, in my opinion, that does not substantially impact the effectiveness of the notification. It's just a sign of a smarter way to deal with it. And so, in my opinion, it's time for more smart solutions to that. Because the notification obligations cost the DPA a lot of time, handling all the notification that comes in. And with the lack of sufficient resources, that's a big impact on the DPA. It also costs organizations a lot of time to actually do the notification to the Dutch authority, because in the Netherlands, the organizations need to serve to the website of the DPA, fill in a long list of questions by hand, and if something goes wrong, for example, a glitch in the internet connection, everything you filled in gets lost. You can start all over again. And then you can see that some of the organizations get a bit fatigued by that. Also, if you need to perform a second notification, what Lukasz was just mentioning about if there's more information that comes to the surface, you can perform a second notification. If so, you need again fill in all the questions by hand. And you need to make sure that you really save the notification number. If you lose the notification number, it isn't even possible to perform your second notification, other than just contacting the DPA. So some of the organizations are a bit fatigued by the way of doing. So in my opinion, we need to lower the threshold to notify by making it smarter. For instance, a way of connecting it to your own privacy management software to automatically fill in all the information that you already created and combined in your own organization. So you don't have to fill in again by hand all those information. It also saves time by making it a lot smarter. So you can focus on the more important things like taking the appropriate measures. At the end of 2017, twice as much notifications were made comparing to 2016. And then the DPA said, on the one hand, it seems that awareness of the duty to report is increasing. That's a good thing. But on the other hand, we are concerned that security is not often yet where it should be. Fair enough, I guess. Otherwise, it won't be a doubling of the amount of notifications. To raise the level of security measures, it could be and should be a way to just take better privacy by design measures. Because implementing appropriate privacy by design measures gives organizations a way to be ahead of possible problems and also possibly prevent data breaches from happening. You could, for instance, think about data minimization or forms of encryption. And if a data breach occurs, but there are appropriate privacy by design measurements taken, it could lower the impact of the notification. For instance, if you process less data, the less data could be compromised during a data breach. But it's not all attributable to the technical measures, in my opinion. the technical measures are always the first thing that comes to mind when people say take security measures. But also the organizational impact is really important and not to be forgotten. Because an organization could have state-of-the-art security measures, technical security measures, but it only takes one individual employee to create a data breach, even if this individual is very well informed and privacy-minded. For example, a stolen laptop from a home, from an employee of a company. Could you say this is due to lack of appropriate measures, security measures, or is this just a case of bad luck? Because we're only as strong as our weakest link. It's one of the things I like to say. You need to focus on sometimes changing behavior of employees to make them more aware of how to handle or take more than just the technical measures to make sure you can prevent a data breach within the company. And in 2018, again, a double amount of data breach notifications to the DPA. This is also the year the GDPR enters into force, and that led within the Netherlands to a slightly change of how we look at the notification, of how we should look at the notification obligation, because you could see some minor textual changes in the articles we had under the Dutch Data Protection Act and now under the GDPR. For instance, the threshold to notify the DPA is lower. Under the Dutch Data Protection Act, it was when the data breach had severe adverse effects on the individual, and now it is when it's likely to result in a risk. That's, in my opinion, a lower threshold. On the other hand, it rises a higher threshold to notify the data subject. It was likely to have adversely affect the data subject to a likely to result in a high risk. That could lead to less bothering of the data subjects because you don't need to inform the data subjects as much under the GDPR. But in my experience with my client, it was also about maintaining a good relationship with their customer or with the individual. So you see often that even though if they were not obliged to inform them on the law, they would, because of the maintaining a good relationship and informing them about taking some measurements like changing passwords, because almost everyone reuses passwords for different things. It's also very difficult in assessing the actual risk. That's something I like to discuss. Assessing risk is a big challenge for organizations, because what constitutes a breach of privacy? Different interpretations for everyone. And that makes it more difficult to assess the risk. In the same event, the circumstances within a context could be totally different. For instance, phone numbers. Phone numbers are often not seen as a sensitive form of data, right? Everyone has a phone number, it's most of the time known to the public. But some people attach great value to keeping their phone number private. So an organization who accidentally publishes this in a public directory, that constitutes a breach of his privacy, of his rights, of his personal sphere, maybe. But same event in other circumstances, where a phone number of a person who is under protection for stalking gets published in the public directory, has a totally different outcome. But how do you assess that risk as an organization? But you couldn't get into the mind or into the personal sphere of a data subject, where you need to think about when you're assessing the risk, about what is the actual risk for him. It also has to do with an organization in itself. How privacy-minded is the management? Is there an open culture to discuss if you, for instance, created a data breach? Or is the management not so open-minded, so that would be a big risk for the organization, even bigger risk, because it leads to people not willing to be telling the organization about the data breach. The higher the risk appetite, the bigger the risks that are to be taken. Because the organization might lead to not notifying the authority or even not structurally fix the problem because they will willing to take the risk. Data breach also leads to improvement of security measures. For instance, with one of our clients who were sending information by letter to their data subjects. It was sensitive data. So, and it happened a lot of time because a common problem in the Netherlands, we all have the same last name, like De Vries. So that will lead to sending the letter to the wrong Mr. De Vries, and thus contains a data breach. It led to improvement of a business process with our client because they were looking at the business process as a whole internally. They skipped the whole sending the letter by a postal service. And not only a business process, it also saves the company money because they erased sending the letters by a postal service. Like I mentioned before, it's about changing behavior of the management, behavior of employees. Be aware of what you can do to prevent a data breach. But also, in my opinion, behavior of the change of behavior of the DPA. Change focus of enforcement. Why focus on organizations that do everything by the book? Well, okay, they had a data breach, but they notified their DPA, they took the rights mitigation risk, they informed the data subject about it. Why not focus on organizations in a sector where data breaches happen a lot, on those organizations who did not ever before notify the DPA about the data breach? Why not focus enforcement on that? Final remarks, then I will stop before Tal will tell me to stop. I think the role of the DPA could change a bit more, offer more guidance to organizations, inform them about how to prevent data breaches from happening, what kind of measures should they take. In my opinion, the DPA has gained enough experience over the 2 years to tell organizations more about this. What can you do to prevent it? And share best practices. Because in the end, it's about preventing data breaches. Like the former DPA chairman said when this notification obligation enters into force in 2016. The obligation to report data breaches is not an end in itself, but a means to prevent data breaches from happening. Thank you.
Thank you very much, Anouk. So this was an excellent explanation showing us what dynamics might be launched by the breach notification scheme. Before we move forward, I just want us to pay attention that there are a few undermining assumptions we're buying into. With regard to notifications of DPAs, we're assuming DPAs have proper manpower to overcome the growing numbers of notifications in real time, which could be arguably true or untrue, and we need to think of different member states and their abilities. And with regard to notifications of individuals, we're talking about all these dynamics of naming, shaming, but we also are assuming that customers can do something beyond complain and then keep on doing what they're doing, which they're very good at. And we need to think, are there actually steps they could do? Either shifting to a competitor, which is unclear that they will do, or bring legal action, which is not clear they could do, and if they have sufficient tools to do so. Okay, so having these skeptical thoughts in mind, we move to hear from Lina Jasmontaite, she'll correct me, who's doing excellent PhD work here in Brussels and Free University, working on these specific issues. Lina, please.
Thank you for this very kind introduction and for having me on this panel, and I appreciate the opportunity to contribute to this both academic and practical debate as introduced by Anders and then elaborated by the other speakers, and reflect on the question, what data breach notifications are good for. So I will argue that data breach notifications in fact do very little for individuals. And before I move on with my presentation, I want to ask this knowledgeable crowd that gathered here, who of you have received notifications after the 25th of May? Okay, a few. And who of those who received notifications found them useful? Not a forest of hands. So I will probably more or less present the view of these people, but definitely it kind of, my presentation will contradict the proposals of the previous speakers and possible impact on individuals. So let's see if it is for them better or worse. So I will start by reflecting on the relevant provisions of the GDPR, and then I will provide a few examples illustrating my main argument. I will then suggest possible alternatives, how we could, what we could learn from data breach notifications, and finally I will point out why and how these data breach notifications benefit IT industry way more than the affected individuals. So let's begin by looking at Article 34 of the GDPR. And paragraph 1 says that the controller, in case of a personal data breach that is likely to result in a high risk to individuals, shall inform them without undue delay. And this seems to be a very straightforward requirement, but in fact it's not, as the subsequent paragraph explains that data breach notifications to data subjects are not required in situations there they would involve a disproportionate effort by the controller, where the controller has taken measures which would ensure that this high risk wouldn't likely to occur. And finally, in cases where the controller has taken measures, appropriate organizational and technical measures, and that those measures were applied to personal data that was subject to the breach. Now, the GDPR on the whole is not prescriptive about the steps that the controller or any organizations should make in order to protect personal data. And it does not really elaborate a lot on what appropriate organizational and technical measures are. But here we can consult Article 32, and it includes a non-exhaustive list of technical and organizational measures that both controllers and processors could take in order to ensure an appropriate level of security. And these include, as many of you well know, pseudonymization and encryption of personal data, the ability to ensure the CIA triad, the ability to restore the availability and access of data after an incident, and of course regular tests. Now, if we translate this more to practical terms, this basically means having encryption of personal data at the point of capture, at rest, and in transit, ensuring backup capability, and continuous revision of a system, as well as the risks that it is exposed to. So basically, this provision can mean a lot of different things to various organizations, and we can be certain that different entities understand the sensitivity and value of the data that they are responsible for in very different ways. But it can be argued that most of the organizations that process personal data implement one or another form of technical organizational measures. Consequently, this means that the wording in Article 34 gives a lot of leeway for companies to decide whether to report a data breach to individuals or not. Now, let's assume that the controller has decided to notify individuals who were subject to the breach, and let's look what this notification should include. So basically, it should describe the nature of personal data that was breached, the categories of data exposed, approximate number of people affected. It should also provide details of a DPO or other responsible person. It should describe likely consequences of a data breach, and most importantly, it should describe measures taken or proposed taken by the controller in a response to the breach. Now, in order to see how this provision plays out in practice, I will introduce two examples of data breach notifications in UK and Poland, the two infamous EU member states. Now, the first one concerns the British Airways data breach that was announced last September. The company released details that personal data theft occurred in the period of the last 2 weeks of August, and as many as 380,000 transactions have been affected. This number was corrected later on, and the total amount of victims is estimated over 500,000. This breach is important, not just because of its size, but an obvious effect on individuals whose data has been compromised, but also because it is one of the first large-scale data breaches under the GDPR. Soon after the data breach was covered by media, British Airways, in the follow-up email on notification, offered credit monitoring for 1 year. Now, the credit monitoring as such seems to be an appropriate and relevant measure, considering that financial data was among the types of data that were exposed. Yet the monitoring period of 12 months can be questioned, because the data exposed is going to stay floating somewhere online in the cyberspace. The British Airways also set up a very nice page on their website, including frequently asked questions and recommendations for individuals how to deal with the data theft. Now, the interesting point that emerges here is, after reviewing this website and the recommendations provided by the ICO in response to the breach, is that they both suggest that individual has to be vigilant when checking their financial records and follow advice by the ICO, the National Cybersecurity Center, and their own bank. This basically means that the affected individuals should stay proactive and deal with the consequences of data breaches themselves. The second example that I want to discuss concerns one of the biggest retailers of home appliances and consumer electronics in Poland, who incidentally announced that it was affected by the data breach in September. What a month it was. In the email addressed to its clients that you can see on the slide, it's in Polish, so I will translate it to you. It basically says that we inform you that there is a probability that the personal data of our clients has been disclosed from an archived database, basically a backup copy of a database. And the email recommends that, considering your safety, you should change password to our website, as well other websites where you have used the same password. And this point came up during the presentation of Anouk and Lukasz. And it's very considerate of this email of the retailer to suggest that you shouldn't answer any emails coming in from unknown sources. And the second example provides clearly a less detailed explanation and no follow-up, yet it is a very interesting one, as the retailer is not certain if any personal data were disclosed in the first place. From these two notifications, I will draw some preliminary conclusions. And they are interesting to reflect, I guess, for this panel as well. So first of all, it seems that international companies are going to be held to a higher standard as notifications to individuals are concerned. Secondly, potentially different standards of data breach notifications are to emerge in the member states. And if this is the case, then I wonder what benchmarks would be and what role would the European Data Protection Board play while setting these benchmarks. And thirdly, This fragmentation in notification practices would consequently result in different level of protection awarded to individuals, and that was certainly not the point of the GDPR. Now, this being said, I could turn to how much good the obligation to notify DPAs and individuals do for controllers and processors as they get their policies, practices, and procedures in place that would allow them handling data breaches should they occur. But I think these practicalities can be left to the other panel that is going to take later on, or to our discussion. And I could also well argue that data breach notifications allow us to learn a lot of different insights, including the ones about geopolitics and state intelligence practices. And here to mind comes the recent Marriott Starwood hacking that was considered the most serious hotel security incident in a decade. So soon after the news broke in media about this data breach, some reporters suggested that actually it was a Chinese intelligence gathering effort dated back to 2014. And some of you may remember that 2014 was the year marked by two large data breaches in the US that concerned the American health insurers and the Office of Personnel Management that keeps security clearance on millions of Americans. Now, alternatively, I could argue that data breach notification contributes to the advancement of transparency principle, as it is now explicitly listed among the EU data protection principles. And it is considered by European Data Protection Board as an overarching principle of a GDPR, which governs how controllers communicate with data subjects. But instead of going all these possible directions, I want to make one step back and reflect on a broader context where both notifications under the General Data Protection Regulation, as well as the Network and Information Security Directive, which is discussed much less at this conference, take place. And while doing so, I want to point out that is very often neglected. And as a rule of thumb, a lot of additional information follows data breaches. This information, in some cases, is more certain than in others, but for sure, it benefits IT software developers. So, for example, they can learn insights about human errors, system glitches, and information vulnerabilities. And in case of a British Airways announcement, some commenters suggested that someone managed to get a script on the website and the details were nabbed at the point of entry, which means that while people were entering their credit card details, a piece of malicious code on the British Airways website and an app was transferring these data to someone else. The other example, and I'm wrapping up here, I see Tal's face like saying that I should finish right now. So the other example that we could consider is the knowledge of vulnerability embedded in hashing in the MD5 hash that is used in many customer databases to secure passwords. And the recent revelations about 773 million record database called collection number 1 clearly signify that this acclaimed security measure is just simply not working. So to conclude, I would say that data breach notifications in fact provide an invaluable source of information to IT companies developing software. These companies should take this information into account when developing solutions for data-rich environments in the future. Now, my conclusion may seem strange at first, as IT companies are not really subject to the GDPR unless they are considered controllers or processors. Yet I think that we should consider ways to urge software developers to take such information into account and implement security and data protection by design principles when developing new equipment and applications.
Thank you very much, Lina. So we'll talk about this more after we hear all the presentations, but just a thought that came to my mind thinking about the BA British Airways breach. How many people, knowing of this breach, will now consider this when making their travel plans? When they get a cheaper airline ticket, will they really opt away from British Airways and bring in another factor? If you're a member of their frequent flyer program, will you just do away with all your frequent flyer points and say, well, there was this breach, so probably I'm not going to fly? Especially when British Airways is a company where the information security is not perhaps central in the trust you build in the company. You're trusting, I guess, the pilots and engineers, and less the company that they took to run their IT system. But this is just a thought. And I know people in Europe might not like this, but much of breach notification came from the United States, starting there in California and moving throughout the 50 states. And Professor Dennis Hirsch from the University of Ohio Law School will tell us about that, as well as other areas of law where he has expertise and have dealt with similar notification schemes. I'm not going to give up too much. Dennis, please.
But just to kind of pick up on Tal's hypothetical there for a minute, what if you were starting your first frequent flyer program and you had seen a listing for the last 5 years of the amount of breaches that different airlines had, and you were deciding between British Airlines and some other similar airline, and British Airlines had a lot of breaches for each of the last 5 years? Could that affect your decision making? We'll return to that question a little bit later. So good afternoon, everybody. I do want to start by just giving a very brief overview of how data breach notification works in the United States. It's a little bit different than in Europe. And then I would like to suggest an idea for how I think data breach notification could work better in the States, and also maybe there's a potential for this in Europe. But first of all, as Tal mentioned, the first data breach notification law was in California, and data breach notification law remains state law in the United States, not federal law. There's been talk about a federal data security breach statute, but that has not yet happened. But most states, if not all, virtually all of the 50 states have followed California's example and passed some form of data breach notification law. They're all different in subtle ways, which makes for very good business for lawyers, because when there's a data breach and it affects people from many different states, then the entity responsible has to comply with all the laws of the various states. So lawyers who have knowledge of the different state laws and how they differ can add some value there. Other than that, I'm not sure that it, since the laws are in many respects similar, I'm not sure that adds a whole lot of value. But we do have state law. And most of the state laws cover the same territory, again, with some variation. So first of all, they address what is the covered information, what information must be released for this to count as a data security breach for the purpose of the law. And most require the name be associated. So name plus other things, name plus social security number, name plus password, name plus credit card number, et cetera. There is a growing trend to find that personal information has been released even without the name if someone could identify the person through the information that has been released, or even could treat the person in a negative way through the information that has been released. So that's kind of more similar, I think, to how Europe treats personal information generally. But that's still a minority approach. But you see already there a difference in different states as to what's the threshold, what's the scope, I guess I should say. What type of information counts for this to be a data security breach? Then what is the trigger for notification? Most states say that someone, unauthorized person or entity, must have acquired the information, and that's enough. Once they've acquired it, I guess able to exercise some control over it, that's enough to require the notification. Others have a higher standard and require that there be some reasonable likelihood of misuse, some danger to the individuals. And so, since, as I'll mention shortly, a lot of the emphasis on notification in the United States is to the data subject rather than to the regulator, I think that higher standard sounds more like the European model, where in order to be required to notify the data subject, there has to be some real risk to the data subject. So, so some US states have that approach. Most of the states have exemptions. For example, if individuals are unlikely to be harmed, then they don't have to be notified. And similarly, if the data is encrypted, in most states, that's an exception. And that could give companies incentive and a reason to encrypt their data. It gives them an exception from the data security breach law. So who's got to be notified? It's the data subject for the most part, right? And so one gets a notice saying we've had a breach and we believe that your information was breached, and maybe there will be some free monitoring of your credit, going forward for a year to make sure that an identity thief doesn't try and steal your credit. About maybe a fifth of the states also require notification to a regulator like the Attorney General or the state attorney, some kind of prosecutor, basically. Since we don't have a DPA, it would be to some state prosecutorial office. But that's a minority approach at this point. And in some states, they give individuals a private right of action to sue under the statute for violation of the statute. That's also a minority approach, although individuals can sue for tort if they can show that they've been damaged. US courts have been reluctant to allow those suits to move forward unless individuals can show specific economic damage. Emotional damage, anxiety is not sufficient for the most part under standing laws in federal courts. So that's kind of the state of, in a very 2 minutes on data breach notification laws in the United States. To my mind, for a number of the reasons already mentioned, this approach is not working particularly well. We continue to have many huge data security breaches. And then when it does what it's supposed to do and people get these notices, they start getting lots of notices. And they don't really know what to do with them, or they start to get too many that they all kind of blend together. I think of it as like the blizzard of notices. And then what do you do with it? Like Tal was saying about British Airways, you could shift, but do you know really if American, I'm going to use the United States Airlines, American or Delta or United is any better? You don't really know, right? So what are you to do? You can watch your credit a little bit more, I suppose. But if the idea is we're giving individuals notice so they can take steps to protect themselves, well, what steps are they really taking? And so I think there is a sense that that these laws are not achieving their desired effect, and so that raises, or not completely achieving it. I think they are achieving it to some extent because it's expensive. Providing the notices is expensive for the companies, and that's the disincentive, right? It's a hassle. You got to pay lawyers. You got to mail all these things out, and so that's and in the biggest examples, it can be bad for the corporate reputation as well. But we just had Equifax, right, which is a credit reporting company, holding highly sensitive, massive amounts of highly sensitive data. But I, as an individual, don't get to choose whether I use Equifax or not, right? It's not a consumer-facing company in that sense, so it doesn't really have that kind of effect. So it's the hassle factor and the cost, and I don't think that's enough of an incentive to justify the appropriate level of investment in the precautions. So I don't think we're getting enough investment in the precautions. So what other models could we use here, and where can we get some ideas? So one place that we could look to get ideas is what I think of as an analogous field, which is environmental law, right? You have the smokestack industry releasing pollution, creating negative impacts on people. Economists would call them externalities. Here you've got data industries releasing personal information, causing negative impacts on people, externalities. There's kind of an analogy there between pollution, if you will, and these types of privacy injuries. In fact, you even see it in the terminology that's used. What do people call data security breaches? They call them data spills, right? Just like an oil spill or a spill of some kind of toxic pollutant. So if this analogy is at least somewhat meaningful, then can we look to how environmental law handles releases, that hurt people in that field? How did they handle that as a matter of regulation? Is there any lessons we could draw, perhaps, for privacy law? So I'm somebody who comes to privacy law from environmental law, so this was my perspective. I was thinking about it, and I was thinking about environmental law. What approach there could perhaps offer something here? And there is an approach in environmental law. We call them pollution release registers. So basically, if an entity that uses more than a threshold amount of toxic substances has a release, they have to report that annually to the Environmental Protection Agency. They have to make an annual report of the amount and type of toxic substances that they released to the environment every year, okay? And if they don't, they face a severe penalty of $25,000 per day per violation. So the longer they wait, it's mounting $25,000 a day every day. And there's a citizen suit provision in the statute that allows, if the government doesn't enforce against them for this, citizens can. So there's a pretty strong incentive to report this stuff. So what does the regulator, the Environmental Protection Agency, do? It takes this information and it compiles it into something called the Toxic Release Inventory, or TRI, which is a national computerized database that contains information on all the releases, what was released, and who released it. Like, they name the companies that released it and where they're located. And they issue an annual report in which they provide all of this information. They also create rankings, like who was the biggest releaser in this, this industry, or in this, for this type of pollutant, or in this geographic area. And I wanted to show you kind of what their TRI website looks like and how it works. And so if you can just show TRI 1 on there. And it's a little hard for you to see, but this is saying, this is kind of the opening page, saying we have this massive data set, this is from 2017, of all the toxic releases, toxic chemicals, and this complete data set is now available. And I'll tell you, when this comes out and these rankings come out, there's front page articles in the paper. The biggest polluter in your region is X, whatever, okay? So let's go to TRI 2. And this is telling you, actually, let's go to TRI 3, sorry. This is telling you can search for the toxic releases where you live, and you can select your state or your zip code. And then it will give you a listing of the releases in your zip code, which is pretty close to where you live, right? And so TRI 4, we get to that. Hang on one second. I did this for Cleveland, a zip code in Cleveland, which is a big industrial city. and it gives the release, and you can tell you towards the top it says quick facts, you know, total production-related waste managed in billions of pounds. Then you see the amount, you know, kind of released. And if you go down to the bottom here of this, and you don't get to see it, if you go down to the very bottom of that page, yeah, there's a chart, and it shows you in that zip code who were the 5 largest toxic releasers. It turns out American Metal Coatings, Inc. released 60,000 pounds of toxic substances that year, and they're by far the biggest, and they would be probably featured in the newspapers, okay? So it's kind of a naming and shaming approach, right? And what happens is companies that are named in this way don't, or I should say, nobody wants to be the highest toxic polluter. Nobody wants to be in that front page article. And so it creates an incentive for these companies to take better precautions. And what they found, I'm going to wrap up, what they found is that this information disclosure led to 45% releases in toxic waste releases. So my core argument is that this could be done for data. If the reporting were to the regulator, and it is in Europe, it's not in most US states, that's why I think Europe could do this even better. The regulator could take that data, compile it, release it. You know, they could actually ask for a report from every company on an annual basis, every company that uses more than a threshold amount of data. And then they could rank it by, let's say, airline. And now you have a very easy way to say, I'm choosing what airline I'm going to be a frequent flyer for. I'll look at how British Airways did. I'll look at how American did. I'll look at how Delta did, you know, Lufthansa, KLM, whatever. And, you know, if I care about this, I'll vote with my feet. And then you really start to get some market pressure on these companies that would get their attention and get them to make the proper investments in the way that individual notices to data subjects who don't know what to do with it, notifications
5 minutes remaining.
to the government that doesn't do much with it, doesn't really put the pressure on them. I think we need a different system that will use this information to create more incentives to do better.
Thank you very much, Dennis. I have many questions, but perhaps we could let members of the audience, if they want. So please, if anyone wants to come. So we'll hear a few questions. Just please come to the mic, or someone will bring you a
I think
mic.
there is a mic. Oh.
Okay,
we
here's
go.
a walking mic.
Hello, good morning. I'm Roger Salonge, PhD student at the University of Turin. Okay, I don't have much time, so I'll have to hurry. First of all, I noticed there was a case of a stolen laptop from the home. If that is a case of inappropriate technical security measures, well, I think from the Morrison case we had in the UK of the Morrison supermarket case, it's kind of difficult these days to actually limit a company's the scope of what constitutes organizational and technical measures. For example, a laptop in the home, okay, why did the company allow the employee to take the laptop in the home in the first place? So that's an organizational measure which was, for me, there's hardly a case of force majeure from what I see in data protection in case of security breaches. And quickly to the second and final, I noticed under the GDPR, the processor can be a natural person or the controller. Okay, so now today I just took a picture of me, and I've already put it on my LinkedIn. And in the background, there are people who have orange flyers, so they didn't want pictures taken of them. Okay, so is that a case of do I need to go to the Belgian DPAs reports? That okay, because if I look at the definition of what constitutes of what should be reported under the GDPR. If the person estimates that will result to a risk to his natural rights and freedoms, maybe I should go now to the DPAs report because I had a picture of people in my background who didn't want to be filmed. So what is the position, I mean, with respect to that in European law? Thank you.
Maybe we collect a few questions. Is there anyone else who wanted to ask? We'll collect and then we'll respond again.
Hi, good afternoon. My name is Leire Crespo, and I'm a student at Leiden University in Law and Digital Technologies, and I was previously a litigator, and here is my question connected to that. If the data breach notification requirement was created to improve the standards of security measures in companies, I think this can be met, and you pointed that out, in 2 ways. First, threatening with reputational damage the British Airways, should I be or should I not? And secondly, threatening with compensation claims. And as opposed to the US case, under the GDPR, the European legislator has actually tried to promote this kind of actions in its Article 80, entitling some associations to file collective claims, and also expressing that non-material damages can be claimed. In this sense, have you noticed, especially I assume in the Netherlands that you've had this before, that companies are worried about this, and in that case, would they be more careful when drafting their notifications to not to self-incriminate them? And wouldn't that reduce the effectiveness of the data breach notification? In that case, shouldn't the regulator have? I was just gonna add. Shouldn't they have added requirement to add in the notification what the cause of the breach was?
So
Thank you.
I think we have time for a quick response from the panel. Does anyone want to quickly respond?
I think these are very practical questions of how the notifications are prepared, and maybe Anouk would be in place to answer that.
To the question mentioned by you, the picture you put on LinkedIn, the GDPR has a exemption in it if you use data for your own, let's call it sources. So not used as an organization, in name of your organization. For instance, if I'll post a video or post a article, etc., from the name of a privacy company, then the company is responsible for the processing of the data. And if I do it myself, I don't know if you could help me figuring out the words I'm looking for. The exemption when you household, that was the word I was looking for. Your household exemption.
Okay, well, that's before the GDPR. Okay, so I think we have to wrap it up, but I just want to point out that some of the remedies we spoke of here, for instance, class actions, aren't really, they don't require a breach notification to the users prior to doing so. So I think we will be success for me if we all walk away from here second guessing and questioning whether this very intuitive remedy that we feel empowers us is really worth the costs and difficulties that might come up here. And I'm going to turn it over to Anders to close the panel.
Well, yeah, time has really been flying, and I think I would just like to thank Tal and the panel for their contributions, and just inform the audience that if you think data breach notifications is an interesting topic, to come back after the coffee break when there will be another session on it. Thank you very much.